One of the ridiculous things that we see in Washington workers' compensation is that the state agency will take terrible legal positions. The claims manager will make a decision that cannot be sustained at law or cannot likely be sustained, and then the injured worker will be put to the proof and to the costs, the expenses of litigation at the Board of Industrial Insurance Appeals in order to vindicate their rights. Well, often it costs $6, $8, $10, sometimes $15,000 for the injured worker to go through one round of litigation at the board. This can consume typically 6 months, maybe even a year of the injured worker's time loss. So great, they win their case. It's a Pyrrhic victory. They spent all their money on litigation costs. Justice was denied. In other systems, and of course, I often go back to the New York system because I practiced workers' compensation in New York for 5 years, many years ago. But in other systems, if the injured worker vindicates their right, they don't get to collect their attorney fee from the state, but at the very least, they get to collect their litigation expenses. We need to change the law in Washington state so that that's the case here as well. Injured workers have to be able to go to court and change their circumstances in order to obtain justice. If you say, great, you can go to court and fight, but you'll lose as much as you win no matter what, then our system isn't actually just. Also, we really need to do a postmortem on the department's litigation practices. It turns out that the department is choosing very poorly, and what our experience is 9, actually more than 9, out of every 10 litigation runs against the department, we win. Well, why is that? It's largely because the department doesn't discriminate against good positions and bad positions. Sometimes they just stick on their position because it's what the claims manager decided. That's a claims manager, by the way, who has no classical legal education or training and doesn't read the law, doesn't practice in the courts, doesn't know how the evidence is going to come in or be understood by an independent judge. And so people who are not fully informed are making decisions that rob injured workers of a ton of money and resources when the intent of the Industrial Insurance Act is to compensate those injured workers. We need to change the system. Finally, the Department of Labor and Industries doesn't pay for its own attorneys. All of that budget comes out of the Attorney General's office. The Attorney General's office is charged constitutionally with representing the decisions and officers of the state agencies, and so naturally has to send literally dozens of attorneys on a daily basis to defend all the dumb decisions by the department. Honestly, the decisions made by the department are sometimes okay. I don't want to disparage them too much, but we have 51 full-time attorneys defending the department's decisions, and they're losing more than 90% of the cases so far as I can tell in my firm. That has to change, and the only way you're going to change that is by making the financial responsibility, changing the ownership of that, and making it the responsibility of the department instead of the Attorney General's office. So we need these changes. We need to make sure that the costs of vindicating your rights are not placed onto the injured workers who can't afford them. And we need to make sure that the department has to actually rationally count beans so that we can reduce the excessive litigation costs we're seeing in this state. These need to be legislative priorities.